Welcome to another episode of Keeping Employment Law Simple. My name is Edward.
And I'm Emily.
And together we are the hosts of this channel. Today's video is all about the implications of sending a damaging and untrue reference. Stay tuned.
An employee of a college left after 8 years and received an excellent reference. Later he got a new post with a university. This role meant he had to get in touch with his previous employer.
Earlier on in his employment with the university, a new HR manager of his previous employer sent an email to the university which was damaging and untrue. As a result, the employee lost his job at the university. The High Court held that although this was not a normal employer reference as such, a duty of care still did apply and the employee won his claim for damages in the tort of negligence.
We will now go through a few implications for employers.
It is well-established law following the leading decision Spring versus Guardian Assurance in 1995 that an employee can claim damages following a reference negligently prepared by an employer.
However, this case goes one step further and says that a duty of care also applies to cases involving other statements made by former employers which are not references. A duty of care applied will arise if it is fair, just and reasonable to impose a duty of care and there is a connection between the negligent comment and the damage suffered. That is the loss of the new job.
Employers need to ensure that unjustified comments or criticism about ex-employees are not made at all unless they can be justified. Employers are of course under no legal obligation to provide a reference for an ex-employee or any other comments.
Employers appear to owe a duty both to the ex-employee and recipient of the reference to provide references and any other subsequent comments that are true, accurate and fair.
Many employers may choose to give only brief factual details stating the relevant dates relating to the ex-employee's employment with the company and the roles that they carried out with no further details. Such employers should state in the reference that it is company policy to only provide a reference in this limited format in order to avoid being construed as providing a negative reference.
Employers should maintain a consistent approach regarding references and other comments or they could be faced with claims for discrimination.
Employers may wish to amend their company handbooks to include guidance not only on references but on all communications regarding all former employees in order to avoid the risk of liability.
Employers should have a clear policy regarding the provision of references, making clear who can provide references and/or any other follow-up comments.
Employers must always take care that they comply with the Data Protection Act, as the reference and subsequent comments may contain personal data.
Some employers use disclaimers stating that no responsibility to the recipient of the reference is accepted on behalf of the company for any errors, omissions or inaccuracies in the information or of any loss or damage suffered as a result of the recipient relying upon it. However, this disclaimer adds little value as the disclaimer has to be reasonable for it to be effective and cannot be used to protect employers against inaccurate information.
Now this is the end. So the summary of this video is only give relevant factual details like start date, end date and role within the company. Nothing else. Till our next video, stay safe. And if you're looking for professional advice and guidance, you can contact us on
hubteam@hrhubplus.com
or 0333 577 0788. Don't forget to subscribe.